Our last speaker will not be physically be with us, but thanks to the technique, we will listen to her by Skype and for the last presentation. She will speak about cross-border family mediation, which is very important for in the context of our seminar. And this is Mrs. Ishtar Kalaf-Newsom, who will present this aspect of the issue. She is a family lawyer, cross-border family mediator, and mediation trainer. She's head of advisory services at MIC. MIC stands for International Mediation Center for Family Conflict and Child Abduction in Berlin. But before joining MIC in 2014, Mrs. Kalaf-Newsom was based in London, where she practiced family law for 9 years with a focus on cross-border family disputes. And prior to this, she was a case manager at the child abduction non-governmental organization Reunite International in London. She has completed her studies at the University Law School and the University of Law in London, and she also holds a master's degree in Near and Middle Eastern Studies and Islamic Law from the University of London. And she worked with intercultural families for the Berlin Youth Welfare Department. And she is practicing cross-border family mediation and has provided diverse training in this field. And she will share with us her experience. You have the floor now, Ishtar. I hope it will work.
Thank you very much, Florence, for the great introduction, and good afternoon, everybody. Thank you to the EJTN and to Sarah for inviting me to speak on behalf of MIC on cross-border family mediation today. I am sorry, I appear only virtually and not three-dimensionally. I won't bore you with the details, but as mediators, we're used to dealing with the unexpected. So, and thanks to Thomas's IT know-how, I am here today, in spite of all odds. I'm very happy to be here, I should say. A little sad that I can't see you, but I believe I can hear you. And so, hopefully we'll have a discussion and there will be room for questions later on. I just wanted to start by asking, before I start with my presentation, asking you, do we have any mediators in the room? So, and this was a show of hands, and I can't see you, but maybe I can hear somebody, Florence or somebody, telling me if any of you, apart from being judges, are also mediators.
There are apparently one person who is a mediator in the room.
Okay, great. So some of this then might be familiar to you, and some of it might be new, but I will now start by sharing my screen. So to give you, you to be able to look at the PowerPoint, and hope it works. I can see it up. Yes, the PowerPoint is visible.
Yes, it works.
Great. Just to give you a quick overview how I have structured the talk. I've structured it around the journalistic W's. So we have what is mediation? I will talk a little bit about that. Why mediate? What are the specifics of cross-border family mediation? Who is involved in a cross-border mediation, and how is it done? Let me start by giving you a quick definition of mediation so we're all on the same page. This is a definition which is the definition of the European Directive on Mediation. And it's a structured process we hear whereby two or more parties to a dispute attempt by themselves on a voluntary basis to reach an agreement on the settlement of their dispute with the assistance of a mediator. So this is the definition here. And then mediation is a structured process, it said. So we have 5 to 6 distinct phases in mediation and approximately 3 to 5 sessions that last some 10 to 15 hours. Sometimes longer, sometimes less. And here on the right-hand side, you see the different phases. The agreement to mediate is the beginning, identifying the issues, defining the issues and interests, negotiating towards agreement.
Sorry, I have to interrupt you because we have a noise in the room.
Is it here from my side?
I don't know. I think. Yes, I will. No, I think it's on your side. Sorry. Maybe you can continue, but I will try to. Yes, it's just finished. Yeah, it's okay. You can continue. I don't know what it was, but it's solved.
Great. So now you can hear me okay? Yeah?
Yes.
Okay. Now the universally accepted principles of mediation are mediation is voluntary. Nobody can be forced to participate in a mediation. It's confidential, so what is discussed in the room stays in the room. The mediators are impartial. They do not take sides. And they do not make recommendations. The self-empowerment is the key aspect. So it's the parties that find the solutions themselves. So the mediators do not give them ready-made solutions, but help the parties to find the solutions. I want to start by saying that mediation need not be right for every family conflict case. There are parents, and we receive such cases on the MIC advisory service, whose conflict is so highly escalated and so deeply entrenched, and where the power imbalances are such that it proves impossible to get them into a room to mediate. But mediation is the right choice for those parents, and we believe this is the majority of the conflictual parents who understand or have come to understand that it is in the best interest of their child and their child's happiness and the well-being of the child if they try to resolve their conflict amicably. And it is these parents that have understood that their ability to co-parent successfully for many years to come depends on learning or relearning how to communicate in a civil, conflict-free manner about their child as they move forward. By contrast, taking the litigation route, or the litigation route without attempting mediation, I should say, tends to escalate the hostilities between the parents. And that is, of course, to the detriment of the child. If you imagine parents having difficulty co-parenting before they embark on court proceedings, will have, after a lengthy court battle with probably a fair amount of mudslinging, many more difficulties co-parenting together. It's somewhat ironically that the parents often lose sight completely of their child and their child's well-being in their litigation fight over custody and contact. So why should parents choose mediation in a family conflict? And why should judges or lawyers refer parents to mediation? And this is the case for cross-border as well as domestic cases. Mediation really is about making the parents refocus on the needs and interests of their child. So mediation helps to safeguard the best interest of the child. And mediation differs from court litigation in that it is It addresses the underlying emotional aspects of the conflict. It puts the child back into the parent's focus. It reestablishes the contact between estranged parents, because often, and we see this here at MIC, the parents that call our advice line have not been speaking for months and sometimes even longer directly with each other. So direct communication is something that mediation can facilitate. And very importantly, it's a safe and confidential space to brainstorm proposals. So you can't take anything outside the room that's being discussed in the room. You may discuss it with your lawyer, of course, but you cannot, for example, write it all up and send it to the court. Mediation de-escalates the dispute, and it's also a way of rebuilding trust and the parents' co-parenting ability. And very important, as we said before, this is one of the principles, there's ownership of outcomes. So the parents have come to the solution by themselves, and that is a big advantage over court litigation. But that's not all. There are many more aspects that are important here. The benefits of mediated outcomes for parents are well known, and they're documented in different research studies. So we have the EU assessment study of 2015, for example, where it was noted that mediation is faster than court procedures, cheaper than court litigation, and it's more sustainable than litigation in court. And this is primarily because the parents themselves are the architect of the agreement. So again, this is about self-empowerment and ownership of the process and the results. And there's a very big research study that you can see here, which was done by the UK Ministry of Justice in 2011, looking at 1.4 million records of clients showing that parents are less likely to return to court following mediation. And mediation users have more sustainable resolutions, and in particular, agreements relating to children were concerned, where the study proved that these were more sustainable. There's also another public consultation study on the Brussels 2A, the assessment study of 2015, saying that mediated agreements tend to be more sustainable and mediation is more cost effective. So mediation is really about getting the parents to understand that now they have ceased to be a couple, they must continue working on a parent level together. It's about changing the mindset of the parents, and mediators use powerful tools and techniques to do just that. Here we have the characteristics of cross-border family conflicts. Cross-border family conflicts are bilingual, usually. They're bicultural, binational. They're usually highly escalated. We have different jurisdictions and legal systems involved. One parent wishing to return home to their home country, and big geographical distances are involved. And often there's also a changed perception of the parents' cultural differences. So something that was initially attractive to both parents, being from different cultures, sometimes becomes much more of a stumbling block, or maybe even a threat. When parents' relationships deteriorate. There's also the fear of losing the child on both parents' sides. For parents living in different time zones, different countries, cross-border family conflicts become very complicated, and we see this here every day. We have a whole spectrum of cases that reach our advice line, so anything from custody disputes to contract issues, cross-border, maintenance and child support, international relocation, parents wishing to move abroad, or one parent wishing to move abroad rather. We have prevention of child abduction cases and actual child abduction cases. At MIC we receive calls to our advice line, our free mediation service, from all over the world. We receive calls by telephone, by Skype or email. And here you can see our areas of work. We have 5 languages at the moment in the office: English, German, Polish, French, and Spanish. We organize the cross-border family mediations for the parents. We train the cross-border family mediators. We do public outreach. We speak to embassies and other public institutions. We also do research and development. So these are our 5 areas of work. The advice line is free of charge, and we have our flyer translated into, I think, 13 languages at the moment, and you can download the flyers from our website. Greek and Hungarian are currently being translated. So just a quick overview of the organization. We started some 17 years ago, as you can see, as a project of one of the big mediation organizations here in Germany, but set up as an NGO over 10 years ago, just had our 10-year anniversary. And have a quick look in the statistics. So last year we had a total of 213 cases. The year before as well, 213 cases. But as you can see, the numbers have increased over the years steadily, and already this year we've crossed the 100 mark. When we look at what kind of cases come in, there were 61 countries involved last year. Most EU countries were represented, and in recent months we've received calls relating to cross-border disputes, also not only in EU states but also further afield. We had Guatemala, Gambia, India, Tunisia, Lebanon. We also received cases without any German link at all. If you look at the inquiries by category, you can see 31% are actual child abduction cases, 39% are contact or custody disputes, 23% are relocation or prevention cases, and then there's an undefined other category, which may be all sorts of other inquiries. The split between Hague and non-Hague countries is predominantly Hague, 81%, but also non-Hague, 11%, but also quite a significant number, 8% of unknown. This is where the parent does not know where the child has been taken. Who contacts the advice line? So fathers, mothers, almost equal, 35, 31%, but it's also family and friends. Judges, 6%, lawyers, 3%, central authorities, 4%, other organizations, and mediators. Who is involved in a cross-border family mediation? And this brings me to a typical case, the story of Pedro and Tanya. It's a case that is slightly based on a real case, but is fictitious, of course. So a typical case, we have Pedro, who's Spanish. He's a chemistry PhD student at Barcelona University. And we have Tanya, a German national who attends Barcelona University for a year under the Erasmus program to study Spanish. So they fall in love. Here you have the little write-up of the story, and move in together and become a couple. So fast forward 10 years, it's now a family. There are 2 children, Ita and Marco, 9 and 10. The family is living in Barcelona. Pedro is a professor of chemistry now. He's working very long hours. Tanya never finished her studies in the end. She's a full-time mother, raising the boys. And Tanya is missing her friends and family in Berlin. She never adjusted properly to the Spanish way of life. And over the years, and more recently, the relationship between Pedro and Tanya has deteriorated. in particular when Tanya discovers that Pedro has been having an affair. So when Tanya spends the summer holidays with the boys in Berlin, as she often does, going back to see the family, she decides not to return to Spain. And she enrolls the children in a bilingual Spanish-German state school. Pedro, of course, discovering that the family, the children are gone, is devastated, and he contacts a lawyer and makes a return application under the 1980 Hague Convention via the central authority. And Tanya proposes mediation, and Pedro agrees, and then they contact Nick. So does this, I don't know if you can, if I can hear you, but does this sound like a familiar scenario that you maybe come across in your daily practice? And I take this as a yes. So, when looking at this, what are the features of cross-border mediation for such a case? So, a mediation is bicultural, bilingual, highly escalated cases that come to the mediation, long geographical distances involved. There's often time pressure, almost always, and the co-mediation model is used in the mediation. And the conflicts are almost always highly escalated, and the time pressure is so intense because one parent, in this case Pedro, has flown in from abroad, usually for a court hearing for a few days only. So the mediation, as I will just explain in a minute, how it is fitted into these Hague proceedings, for example. There's only a few days, and the different languages and the cultures of the parents involved exacerbate the conflict often. Mediation is, of course, about communication skills. It's about communication tools and about conflict management. And being able to understand cultural difference in communication and conflict is crucial, as is the ability to communicate in the parents' mother tongues, even if only sometimes when there are, due to stress or other reasons, a parent wants to switch into their mother tongue, because let's not forget, these parents have often a shared language. One parent has a different mother tongue, but very often in our mediations there are three languages on the go. So the parents speak English with each other, but have different mother tongues respectively. So the advantage of being able to communicate with the parents in their mother tongues is, if you have bilingual or trilingual mediators, is of course that communication remains direct, and you do not need an interpreter, you do not need someone to translate. And this is really, oops, I've gone a little too far. So this is the co-mediation model that we use to mediate here our mediations. It's we call it the 4B mediation model. The mediations are bicultural, so we ensure that the mediators are matched, ideally with the parents' cultural backgrounds, and bilingual, so mediators again are matched with the parents' linguistic backgrounds. The mediators, wherever possible, are bilingual, bicultural, and biprofessional. So we have always a mediator with a legal background, a lawyer or a jurist, and the other mediator with a psychosocial background, pedagogical background. And of course, we try and match the gender of the parents. So it's usually a man and woman team. And this is a model that works really well in our mediations, we find. And it's recommended for these cross-border child abduction cases by the Hague Conference Guide to Good Practice, which you may know. This explains it a little bit more with some graphics. So the co-mediators speak the common language of the parents and their mother tongues. The co-mediators are familiar with the cultural differences in communication, because different cultures fight differently conflict is settled in different ways in different cultures. And the co-mediating usually consists of a man and a woman, or is matched to suit the parents' genders. And it's bi-professional, so legal and psychosocial. How can we do this? This is quite difficult, and sometimes we have to be inventive, so sometimes we can't satisfy one of the requirements, but usually we manage. We have our international mediators network of mediators trained by us. There's 150 mediators, bilingual, cross-border mediators on our list, who are based at the moment in 27 countries and together mediate in 30 languages. There's also an informal global network of mediators. And our trainings are held in English. Every year we hold our cross-border family mediation training. It's a 50-hour training, but also in Singapore, probably again this year, and in Japan. And the training entitles mediators to be listed with Nick, and also on the network of cross-border mediators, of which Nick is a founding member. And for example, in the September cross-border family mediation training, the course brought some 11 countries to Berlin. So mediators from 11 different countries: Belgium, Canada, Germany, Greece, Japan, New Zealand, Peru. So it's a long list. And we have over the years trained some 300 mediators worldwide. Children can also be included in the mediation too. So just last month, Nick, with the support of Center Eco, developed and carried out a training for child-inclusive mediation as part of the Voice project, which was an NEC co-finance project. Parents often tell us that they wish they had known about mediation before embarking on the litigation route. So it is important to spread the information on mediation more. Other parents are unsure what mediation is. In fact, we regularly have parents on the telephone asking us to organize a meditation for them. So yes, many lawyers too surprisingly still think that mediation is counseling. There's a great deal of uncertainty still, or a great deal of information that needs to be spread about mediation. We certainly believe here at MIC that lawyers are potential key referrers to mediation and are very crucial in the mediation process. But not enough lawyers refer parents. But the lawyers who do refer parents are often mediators themselves and know that they will remain involved throughout the mediation process. So it's not a case of handing it over to the mediators and then the lawyers step out, but in fact the mediation needs the lawyers to be involved. Not only are they key referrers, but they advise the parents throughout the mediation process, because mediation complements legal procedures in most cross-border family disputes. It is not a substitute for them. How are the lawyers involved? We can see that the lawyers advise the parents prior to the mediation. When the parents call up, often they do not have a lawyer, they have not consulted a lawyer, and this is something we always tell the parents: they must get legal advice, because you have to go into the mediation informed. The lawyers advise the parents during the mediation, which doesn't mean they sit in, but it means they are available on the telephone for questions. And of course, at the end, they must check the mediation agreement. Both parents have their respective lawyers, and both lawyers need to check the mediation agreement to see that it is all proper and in the correct terms. Also, very important, The lawyers provide assistance with the recognition and enforceability of mediated package agreements in the other jurisdiction. And this is something I will come to a little bit later on, and a bit more, I say a few more words about this. We have also a list of lawyers, currently 20 countries represented, who have expertise in cross-border and child abduction cases. And this is very important because it's such a specialized field that often we find that lawyers who take on the case might treat it as a domestic case, not realizing that there is such a thing as the Hague Convention. There are international instruments that apply, and that often makes matters much more complicated, of course. So expertise, training for lawyers is crucial here. You may remember the LEPCA training. Maybe some of you attended it, took part. This was one of the LEPCA 1 and 2, an advanced training for child abduction lawyers. It was an EC project which Centro Eco and MIC was also involved in as project partners. But perhaps more crucial, even more important when it comes to referrals, are the judges, the role of the judges. And this was also noted in the EU Parliament study, Rebooting the Mediation Directive. What was mentioned were concerns that mediation might unduly delay proceedings in Hague cases, because remember there is a 6-week time limit by which the proceedings have to be concluded in the Hague court. But this is an unfounded fear, as evidenced by this mediation model, which is operated in England, in the Netherlands, and in Germany. In Germany, it's a pilot project which was created by Hague liaison Judge Sabine Brieger in Berlin and by MIC. Here, mediation is embedded into the child abduction proceedings. So 2 hearings are listed, not just one, and they are 10 to 14 days apart. And the first hearing is a very short hearing, where a mediator attends court advising the parents on mediation, often in a different language, in the language of the parents. If the parents agree to mediation, then the mediation takes place over 2 to 3 days before the final second hearing. And that is, of course, where the judge will make the decision whether it will be return or no return. And MIC promotes this model regularly at the biannual Hague Judges seminars, which are organized by the German Central Authority here and which are chaired by liaison Judge Martina Erb-Grünemann, who spoke yesterday to you, and who promotes and uses this model very much. And as a result, we have more and more judges in Germany of our 22 specialized Hague courts. So here in Germany we have 22 Hague courts, not just one as in England or in the Netherlands, but more and more judges are trying it out. Other countries should follow suit, and this is also something that I will say a few things about later in this new EC project, Amicable, which we have just begun, where we will promote this model in 3 different countries. So a judge's recommendation to parents that they should give mediation a go is rarely refused by the parents. Judicial encouragement, so the judge's authority used here, is extremely helpful in getting parents to try it out. Finances are still a hurdle, of course, in many cases. There are many more parents wishing to mediate, but just simply cannot afford it. In Germany and some other countries, the central authorities assist, providing funding for parents on low income, on child abduction cases, and also on contact access cases brought under the Hague Convention. But what are the issues that you can deal with? Well, when we're talking about finding a solution in a Hague case, in a mediation, and a mediation agreement deals really with a wide scope of issues, for the whole package, we say, the package agreement, because any issues, return of the child or not, living arrangement, custody arrangement, contact with a non-resident parent, holiday contact, birthdays, religious holidays, cultural and religious upbringing, bilingual language upbringing, finances, and criminal proceedings. And this is very important because often, in many cases, child abduction is a criminal offense, and one parent will also start criminal proceedings as well as civil proceedings. And it is very important that this is addressed so that one can try and have these lifted before a parent returns. Those are all issues that can be settled in a mediation. And the advantage is, of course, clear. Because once these issues have been settled, there will be no need to return to court in the other jurisdiction to decide on custody. It shortens the litigation and therefore serves the best interest of the child because there's no need to return to court. Or, if an agreement is made on an interim basis in a mediation, then mediation provides for a soft landing for the returning parent and child. So they know what they are returning to. The modalities of the return can be settled in the mediation. Sometimes, of course, if no solution, no one agreement is found, the mediators will start working out two scenarios. So one, what happens if the child returns? What will contact look like? Where will you live? Etc. And what if the child stays? So you have these two scenarios, and this is what you come back to the judge with, and then the judge, of course, at the second hearing will make the decision as to whether to return or not. The success rates of the Hague child abduction mediation cases are quite promising. So I've just got here a list for you of cases of 2015, 16, and 17, where the parents managed to conclude a memorandum of understanding, which is an agreement in mediation, either partial or full. And as you can see, the numbers are very good. So we have 67% in 2015, 90% in 2016, and 83% in 2017. Another key area that MIC is looking into as part of our research and development area of work, which is crucial in this field of mediation, concerns the recognition and enforceability of mediated agreements in the EU. In particular, when we're talking about these package agreements. Here, as you know well, the situation, the jurisdictional situation is extremely complex, and cross-border recognition and enforceability of package agreements is complicated and complex and a little uncertain, because we do not have any EU legal instruments or international conventions that provide a straightforward means for the enforcement of such package agreements. So this may well be another obstacle to the uptake of mediation. So I think that greater certainty of enforceability of mediated agreements would very, very likely result in an increase in the numbers of mediation, because lawyers also would more readily refer to mediation. This project here that you can see, the Amicable project, is a project that where MIC is the coordinator, the applicant, where we have just been granted funding for, together with 3 partners and experts on private international law from different EU member states. So we have the University of Alicante in Spain, and as part of the project, a Spanish national seminar will be held in March 2020, and there will be workshops and talks. The idea being that this best practice tool that we are developing under this project, there will be a EU general best practice tool and 4 country-specific best practice tools, that these will be tested out. So we will have a country-specific tool for Italy, one for Poland, and one for Spain. These national seminars, you are very welcome to attend. If you happen to be a Spanish judge, because they're primarily aimed at judges, but also lawyers, and of course mediators will participate. And the workshops will be held in the local languages. So we will have the University of Alicante, as I said, in March. The dates will be out shortly on our website. Mainly in Spanish for the workshops, some translation provided for the plenary sessions. And we really want your input. So the judges' input is very important on how we can, whether this tool needs to be tweaked in certain ways, but it's really meant to be a roadmap that guides lawyers and judges for the benefit of the parents through the enforcement process. So to make it simpler and easier to enforce these package agreements. We have the University of Wrocław in Poland. A Polish National Seminar is planned here for April 2020. And we have the University of Milano Bicocca, where a seminar will be held in May. Again, the workshops will all be in Italian, and translations provided for the plenary talks that have to be in English, or because the speakers happen to be English. But it is very important that we receive the feedback here from the national judges who know this area well. At the end of the project, there will be a final conference in Berlin in November, December 2020, and you are very much cordially invited to attend this. The project really seeks to plug this gap concerning the enforceability of mediated agreements. So we're here building on the work of the Hague Conference that they have done already in the field of recognition and enforceability of package agreements. There will be a website also of the project where you can check back also on these national seminars and any information, the tools, the draft tools will be published on that website in due course towards the end of the year. Another area of research that Nick has been involved with is developing a concept for mediation in non-Hague countries, with countries where there's no international legal instruments available to assist the left-behind parent and the abducted child. So mediation provides really sometimes the only chance to at least facilitate contact between the left-behind between the abducted left-behind parent and the abducted child. So this is particular concerns the countries from the MENA region, which are not signatory states to the Hague Convention in most cases, Morocco and Turkey being the exceptions. And here it's very interesting because alternative dispute resolution has a long tradition in these countries and is very highly regarded as the preferred option to resolve conflicts, including such family conflicts. So last year, MIG, with the assistance of the German Ministry of Justice, was looking at its caseload and statistics and conducted some research into this field, where we convened an expert meeting on this particular topic. The experts that came from all over Germany were bicultural mediators, lawyers, and social workers with fluent language skills in Arabic, Farsi, Turkish, and Dari. And based on this expert meeting, MIG has developed, or still working on developing, a slightly adapted mediation model and a training concept for mediators, which, funding permitted, should be piloted soon. In March this year, MIG participated in the Hague Conference Malta Process Working Group meeting, and we reported on the results of this expert meeting here. So these are hopefully, we will watch the space. Come on and look on the MIG website. There will be more developments soon, we hope. There's just for you some dates if you happen to want to, if you're interested in our training and workshops. We have, as I said, mediators, but also quite a few judges participate in our trainings. And in particular, the November workshops might be interesting for you because it's open to everybody really, from related professions, mediators, lawyers, etc. There's a seminar on conflict and culture with international trainer from London. There's a workshop on peace mediation and another one on online mediation. Yes, this is a publication on cross-border family mediation, which really contains everything that you should know or want to know, perhaps, on this topic. Also very interesting comparisons on costs, mediation versus litigation, draft agreements, etc. And we really believe that we need the support of judges in particular by supporting mediation and referring parents to mediation, in particular in cross-border and child abduction cases, so that mediation will become the preferred and hopefully soon the affordable option for all cross-border family conflicts. The aim being, of course, to ensure that the children's well-being is safeguarded and that their best interests are protected. And this the final slide, if you have any questions. Then I'm very happy to take your questions or any comments.
Thank you, Ishtar. I asked the audience if they have questions.
Thank you.
Do you have questions or experience to share with us? No?
The question is, how does the court apply to the mediation cross-border? How does the court apply to mediation cross-border? How does the court apply to it? Yeah, how does it, or the judge or the, yeah. How is it done practically?
How is it done? How is it done in practice? Yes. So in practice, and this is this model that's they're using in England and in the Netherlands and increasingly now here in Germany. The judge will list the two hearings. So he has a child abduction case, or she has a child abduction case to decide, and to make sure that the mediation doesn't delay proceedings, the judge lists one hearing just to have the mediator explain what mediation is. It's a very short hearing. And then if the parents say yes, the mediation will take place. It's a pressure cooker mediation, we say, 2 to 3 days after the first hearing. And then there will be a second hearing where hopefully the parents have come to a result, a solution, or the judge will take a decision. So this works very well in England. This has always been done that way with the two hearings. They were called the directions hearing and then the substantive hearing. But now, only last year, I believe, it became a practice guidance by the president of the family court. So now really in every child abduction case, and that's quite an important development because England has the highest number of child abduction cases in the EU. I think with some 500 or 600 cases. So every case, there will be a mediator available attending the first hearing, giving the parents a chance to mediate, and then there will be the final hearing. It's embedded in the court proceedings. Does that answer your question? I hope.
If I can clarify, the question is more to know whether or how you get a MIC, you designate MIC mediators. When you are a judge, you are in a hearing, you have these people in front of you and you want to suggest to go to such mediation, but we have national mediators who are not properly equipped for such an international cross-border mediation. So how do you get to MIC?
So the judges know that there's this case that they need to list. The case comes in to the court from the central authorities or other ways, and so what they do is they ring us up. They say, I have a case coming and I'm listing it for such and such a date. The parents are Polish and German or Swedish and something else. Will you be able to send a mediator to the court on that day? And sometimes the court sets the date already, and then we find mediators. So this in the German system, we have, of course, mediators abroad. We have mediators in Poland, we have mediators in Sweden and Spain. So technically, a Spanish judge would be able to look on our website, find the Spanish mediator, and or contact us, and we would refer it. So this is the way it works. It's done directly to judges, or courts make direct contact with me.
And is it possible that the judge appoints a mediator that he finds on the website of MIC, just appoints him as the first responsible mediator, and that this mediator organizes the co-mediation with somebody of MIC?
Yeah, it's technically possible, but it's a lot of work for the mediators, because these pre-mediation calls that we do take a lot of time, because we check the dates with the parents, the times, we look into trying to find them financing, and it's best that the mediators are neutral. So if they start having too many discussions with one parent or the other parent, then there might be a feeling even. The other parent might say, oh, she has spoken to my husband for hours, she's not neutral. So by giving it to a pre-mediation service, and everything here is confidential, we don't pass things on between the parents or to the court, but there's no danger of any issues of impartiality coming up. And when we give the case to the mediators, everything is clear: the room, the date, the languages. So it's all set up for the mediators. So they just turn up for the mediation, and there's no extra work involved or issues of impartiality arising. This is our experience, but can be done differently, of course.
Any other questions? Yeah.
Good afternoon. I would like to know what is the general cost of the of a mediation, and because in general you said it were the parents that used to pay, and
yes,
they need to agree. So the first question they'll ask it will be how much this will cost us.
Yeah, that's a very good question. So it is on average it's 100 euros per mediator per hour, and the parents usually split the cost. So some mediators take 80 euros, some take 120. We say on average 100, but ultimately it's the mediators who fix the costs. As I said, sometimes in child abduction cases where parents are on low income, the central authority will pay. The German central authority funds mediation, and other central authorities also do this. But yes, we've had embassies funding mediation, so we always try and find ways of sourcing funding, but it is, of course, an obstacle, and in most countries, finances for mediation, there's no mediation aid. In England, in the United Kingdom, there is, but I'm not aware of other countries really where there may be others, but that is still an obstacle of funding. But it's still, I suppose, cheaper than, or I know it's cheaper than hiring a lawyer in most cases. You will still need both, but you can, with 10 to 15 hours, the the mediation process is quite restricted to
Yes, I understand.
no budget.
I saw in your presentation that you had cases from Portugal. In Portugal, the cases that you had, it were the parents that paid, because I don't know any authority or central authority that can pay the fees of the mediator.
Yeah, I can't remember, I'm afraid, which case that may have been, but it may have been a case where also the left behind parent, so let's assume the father is Portuguese, the mother is the taking parent, taking the child to Germany, the father then has to attend the Hague hearing here in Germany, and if he is under a certain threshold, he will also receive funding from the central authority, the German central authority. So if both parents are on low income, no matter whether it's the German parent or the foreign parent, they may be funded, these mediations may be funded by the central authority.
Okay, thank you.
Yeah, thank you.
No other questions? No? I would like to thank you very much for your presentation. It was very interesting, I think, for everyone, and we succeeded, hopefully.
Thank you very much. It's a little strange talking to a monitor. I wish I could see you all, but
I try.
no, it's okay. I wow, okay. So hopefully next time we see each other face to face. And I'm sorry I couldn't be there.
Okay.
Well, many thanks for your efforts, and we keep in touch. We say bye now. We continue with our program, and I will be in touch with you via email after the seminar.
Thank you very much. Have a great rest of the conference. Thank you.
Thank you.
Bye. Bye.
So we arrived to the very last part of our program. In your folders, you will find a sheet which says post-training assessment, knowledge assessment, like at the beginning, if you remember. If you lost your folder or you don't have it, I have a few extra copies so I can give you.